Good afternoon, everyone. So I just wanted to thank the McGill Institute of Health and Social Policy for giving me the opportunity to be here and to present my research. It's really an honor to be alongside this diverse panel of policy experts. The past day and a half has really been enlightening. When I started researching the international legal dimensions of cannabis legalization, I was really struck by how complex the issue is. The more I researched it, the more complex it became, and this conference just even takes it further than what I thought it was. So it's really great to hear those perspectives. By way of background, I'm here today to speak about the international legal dimensions of cannabis legalization. When I began to study this topic with my law professor, Stephen Hoffman, at Osgoode Hall Law School in York University, there was really just little discussion at the time, so that was around 2015, 2016, 2015, on Parliament Hill as to how Canada was planning to reconcile its domestic cannabis legalization plans with the international legal obligations of the treaties that it's also party to. So the aim of our research, which is forthcoming in the Ottawa Law Review soon, was to ensure that international law was taken seriously as parliamentarians moved forward with the cannabis legalization bill. And before going any further into the substance of our research, I just want to note that I'm not taking a public health or moral stance on cannabis legalization. When I came at this research question, I really was looking at it from an international legal perspective. And I'm in my third year of law school, and as I'm thinking of coming out of law school, I'm interested in international law. And the reason why I'm interested in international law is because it's one of the few areas of the law where the subject of the law, and that's the state or the country, is also the source of the law. And this is particularly true in international treaty law. So what I mean by that is that we have a vast compendium of international treaties in place today. They address a wide range of issues that touch us on a daily basis. And in order for those treaties to work properly, the main enforcement mechanism is that we're relying on the other countries that are party to the treaty to implement those treaties in good faith. And so that's where my interest in this issue comes in. And I just want to start off the presentation with a note that the rules of international treaties, they exist and they have weight because we agree that they do. So it's no small issue to violate an international treaty. Now, in terms of what the treaties say about cannabis legalization, there's really no mystery. Cannabis legalization does violate the international treaties, and we've heard from Mr. Leonardo Costa, who spoke eloquently about the Uruguay experience earlier this morning, that they were aware of this as well, and that they had their reasons for doing so. I'm going to touch on how those reasons don't really apply to Canada, but I don't want to end on a bleak note and say cannabis legalization is not possible. In fact, the whole point of our treaty was, from an international law perspective, of course, but the whole point of our treaty, of our research was to say that it is possible, it just needs to have been done in a more thoughtful way from the beginning. Now, so I'm just going to talk briefly about the international drug control regime, talk about it in a little bit more detail than maybe you have heard so far. The international drug control regime is really defined by 3 United Nations treaties. Canada is a party to all of the treaties. The first of these treaties is the Single Convention on Narcotic Drugs. This is also known as the Single Convention, and the reason it gets its title is because at the time that it was implemented in 1961, it really merged all the international agreements on drugs and drug control that were in place at the time, and so it became known as the Single Convention. What it does is it sets the baseline prohibitive measures that countries are expected to take on drugs. I'm going to be talking a little bit about a provision within the Single Convention, the general obligation that is important for our purposes. And so that was the Single Convention laid the baseline and the foundation for the international drug control system. By the 1970s, there was also a dramatic increase in drug use, and that prompted countries to convene again. And at that time, they had to conclude two new significant agreements. The first was the 1972 agreement to amend the Single Convention. This was called the 1972 Amending Protocol. In that amending agreement, countries agreed to strengthen efforts to reduce the supply and demand for drugs. And they also actually incorporated a little bit more of a public health view of drug policy on an international level. So they started there was a provision introducing that public health view and it's strengthening it and requiring countries to really take that more seriously. And by that I mean rehabilitation and treatment of drug dependence. The second agreement was the 1971 Convention on Psychotropic Substances. And this was really, as its title suggests, it was a reaction to the high uptake of synthetic drugs, such as amphetamines and benzodiazepines that came in at that time. These substances were not previously covered by the single convention on narcotic drugs. And so the Psychotropics Convention sort of reiterated, with minor variation, many of the provisions in the single convention, but it also applied them to the psychotropic substances and synthetic drugs that started appearing at the time. And then in 1988, we had the 1988 Convention Against Illicit Traffic in Narcotic Drugs and Psychotropic Substances. This is also known as the Trafficking Convention. And as you might guess from their title as well, it provided more comprehensive measures to combat drug trafficking, which started to become a more consistent problem in the 1980s due to the rise of organized criminal groups. So the Trafficking Convention allows for comprehensive measures such as extradition and confiscation of assets to tackle the illicit production of drugs, their trafficking, and the demand for them. Now, these three treaties and their international bodies that implement them are what we call the International Drug Control Regime. So from here on out, when I'm talking about that, that's what I'm referring to, these three treaties as well as their bodies. And so, as I mentioned earlier, cannabis legalization does contravene these treaties. The paper that I wrote co-authored with my professor, Stephen Hoffman, talks in detail about the provisions that were contravening. But to summarize for the purposes of this presentation, I'm going to put out two provisions of the treaties for you. The first is the Single Convention, Article 4C of the Single Convention. In it, it states that parties have a general obligation to take such legislative and administrative measures as may be necessary to limit exclusively to medical and scientific purposes the production, manufacture, export, import, distribution of, trade-in, use, and possession of drugs. Now, taken on its own, this general obligation does not require the criminalization of drugs, but it certainly does not encourage legalization either. And what we can take away from this provision is that there must be some form of prohibition on drugs, but it doesn't say exactly what kind of prohibition it needs to be. Moving along to the Trafficking Convention, the most direct provision here is Article 3.2, which states that treaty parties must establish as criminal offenses under their domestic law, when committed intentionally, the possession, purchase, or cultivation of narcotic drugs or psychotropic substances for personal consumption, contrary to the provisions of the 1961 Convention, that's the Single Convention, or the 1971 Convention, that's the Psychotropics Convention. And to sum this up, in other words, for 180 states that have adhered and ratified the drug control treaties, and by the way, the drug control treaties are some of the most widely adhered to treaties in the world, there has to be some form of prohibition on the possession of cannabis for recreational use. I just want to note that narcotic drugs, quote unquote, or psychotropic substances are not explicitly defined in the treaties either. But the substances that are to be restricted or prohibited are listed across the schedules of the Single Convention and the Psychotropics Convention. Who determines this? It's the Committee of Experts at the World Health Organization. And when they're deciding whether to schedule or deschedule a drug, they're really doing a balancing act. They're weighing out whether there is a therapeutic potential for the drug or whether there's a potential for that drug to induce drug dependence and abuse. Cannabis in particular is listed in Schedule 1 and Schedule 4 of the Single Convention, and it's subject to some of the most stringent control measures that are set out in the treaties. But I should also mention that there is a review of cannabis extracts that's coming up at the World Health Organization in June 2018. Now, the thing about treaties is that they're trying to manufacture a consensus among a wide range of countries. And this requires them to have some built-in flexibilities in order to allow that consensus to happen. The drug control treaties also have some built-in flexibilities. I'm going to briefly talk about them, but I think we're also going to be hearing about from some experts who have leveraged these flexibilities as well later on today, specifically from Portugal. The first of these flexibilities is that criminal punishment is not necessarily required. So you may recall from the Article 4C of the Single Convention, which I put up, that it doesn't say you need to have a criminal punishment for the possession of drugs. So Portugal has leveraged this. This is, in other words, this flexibility is what you would call allowing decriminalization. And so that's something that's clearly allowed within the drug control treaties. The other flexibility is that treaties don't require states to have, in law, some form of punishment, but they don't require countries to enforce those legal provisions. And so the Netherlands, famously, has taken advantage of that flexibility as well by not enforcing their prohibition against people possessing small quantities of cannabis, even though within law it is prohibited. And finally, the treaties also allow room for constitutional override. And by that I mean that there's no expectation that countries have to violate their own constitutions in order to be compliant with the treaties. The example of this that I'd bring out is Bolivia, that took advantage of that flexibility by actually changing its constitution in 2009 to incorporate a right to chew coca leaf. Coca leaf is of cultural significance to Bolivia. So when they did that, they withdrew from the treaties, they changed their constitution, they came back into the treaties with a reservation to say that the provisions of the drug control treaties on cannabis do not apply to Bolivia. With respect to cannabis legalization, the president of the International Narcotics Control Board has stated that there is no flexibility in the conventions for allowing and regulating any kind of personal use. And for those who may not be for those who don't know, the International Narcotics Control Board is responsible for monitoring and enforcing the compliance with the treaties. So I've talked about all of the prohibitions on this, but nevertheless, we do have 2 countries that have regulated markets for cannabis. We've heard from both of them here at this conference. Both are contravening the treaties, but they have very different logics for doing so. In the United States, we have 9 states, including the District of Columbia, that has some form of legalization for non-medical cannabis use, and this number is only expected to rise in the US. This is a bit of a paradox because the US has actually historically been one of the strongest defenders of the drug control regime. Now, the way that they've reasoned with the international drug control authorities is that in the US, there's a unique particularity to the criminal law system. They have, in the states, independent criminal lawmaking powers that are independent from the federal government. And this has allowed the states to fashion their own drug control laws independent from the federal government. Up until the Trump administration, this seemed to be a process that's completely that has stabilization, that more states can continue to do this. But now with the change in administration and the repeal of certain protective measures for states to implement their own drug control laws, there may be a change in that respect. In any event, for the Canadian perspective, I should point out that Canada's federal, as many of you know, the Bill C-45 is a federal government initiative. The federal government has executive powers to ratify the treaties, and therefore it's not, this is not a logic that Canada can leverage from. Now, Uruguay, as we know, Uruguay also began regulating the sale of cannabis for non-medical use. Their creation of a regulated cannabis market is said to be driven by concern for public health, security, and human rights. And these are themes that have explicitly come out in the legalization of the Uruguay law. They have explicitly anchored their law in human rights and public health and concern for those values. So it's, on that note, I should say that it is a well-recognized principle of international law that specific requirements generally trump broad requirements. And so we have specific requirements of the UN drug control treaties. That becomes a little bit more difficult to cite broad human rights treaties that are not specific to drugs or to cannabis. The other aspect of it is that we, here in Canada, Bill C-45 has not been presented to the Canadian public or to the international community as a human rights-centered bill. It has not, we have not leveraged from that argument. We can't even attempt to bring out that argument right now. So what options do we have? I want to put out that we have several options. None of them are great, and none of them are really particularly fun to pursue. But if we're serious about this, I think this is the path that we have to take. We really need to do this the right way. And we need to do it the right way, not just for Canada, but we need to do it the right way for the international community. There's many countries, so Canada is a G7 country that's trying to pursue this. There's many countries that can't be as bold as Canada. And so in order to pave the way for them, we need to sort of do this in an internationally acceptable way to allow them to also leverage from what harm reduction or public health-centered or human rights-centered drug laws they want to put in place. So the options that we have are that we either amend the treaties, we either provide a creative justification for contravening the treaties, we conclude an agreement among like-minded parties, which is an inter-se agreement, or we withdraw from the treaties. And obviously the other option is that we change our constitution to include a constitutional right to consume cannabis, which does not seem to be a very feasible way to move forward. Negotiations will only get Canada so far, unfortunately. So negotiations to amend the treaties will only get us so far because there are about 32 countries currently in the drug control system at the international level that have death penalties for drug smuggling. Some have also suggested using creative lawyering. And so, for instance, the Article 4C that I again put up on the screen earlier states that you must have a prohibition except for scientific or medical use. Now, scientific use, we could have leveraged from this if we had presented Bill C-45 as a intergenerational public health experiment, a longitudinal experiment, to see what the effects of cannabis are on the Canadian public. But that has not been the case. That has not been how Bill C-45 has been presented to the Canadian public or to the international community. Now, some advocates of some academics and advocates of drug legalization have proposed the possibility of a little-known mechanism of international treaty law, and that's the inter-se mechanism. So I guess the best way to describe the inter-se mechanism is that it's an agreement within an agreement. And so it's an agreement among like-minded parties to change the provisions of a treaty among these like-minded parties, to change the effects of that treaty for these like-minded parties. And that is allowed as long as the change in the effects of the provision don't detract from the enjoyment of the treaty for other party members. They're also allowed as long as they're in line with the object and purpose of the treaties. If Canada were to go about this as a mechanism, it could expect the collaboration of Uruguay, for example, or it could expect the collaboration of the Netherlands. It could expect, for instance, Jamaica to collaborate. But the downfall of this, and I'm a messenger here, I'm not advocating for any particular route, but the downfall of it is that it's not, first of all, there's no precedent in the international drug control system for this, and it also has just a lack of examples in history. It's also worth remembering, I think, that joining an international treaty is an exercise of a country's sovereignty, and so withdrawing from them is an equally valid exercise of a country's sovereignty. And we have withdrawn from treaties for less convincing reasons in the past. So, for instance, in 2013, we withdrew from the Convention to Combat Desertification. At the time, former Foreign Affairs Minister John Baird had reasoned that Canada had a disinterest in continuing to support talkfests and bureaucracies. Canada also controversially withdrew from the Kyoto Protocol in 2011. I think what makes treaty withdrawal understandable in this case is that, as nearly everyone who has some knowledge of the drug control treaties would agree, they're very old, and they date back, they have a logic and a reasoning that dates back to before the League of Nations. And so having these treaties in place for Canada to withdraw is sending a clear message to the international community that this is not working anymore. These treaties are no longer fit for purpose. And I think it would send that clear message would initiate a cascade of amendments or changes to come for the international drug control regime. So I think I should just quickly, I had some more to say, but I'll quickly say that all of this matters because undermining international law does have real consequences, and it's not just about our reputation. I think that international law is our best chance at solving some of the world's most pressing problems. And we're in a world today where the rules-based order that we had from before is starting to fall apart. We're starting to see countries, consensus fracturing, countries saying that we don't need to follow treaties because it doesn't suit us. And I think that's a dangerous precedent to set for the world. We can't go back to a country that has human rights abuses and say you're violating human rights treaties because we're also doing the same. Now, with cannabis, it's not so much perhaps a big issue, if you will, but it is setting a precedent. And I think that we should be holding ourselves up to a higher standard than that. We're better than that, and we do have mechanisms to be in line with international law while also going forward with the policies that we think we should be doing, we should be pursuing in this country. Thank you.